I think we're ready to get started. This PowerPoint was prepared not by me, but by the Florida League of Women Voters Juvenile Justice Committee. And so it is for the whole state of Florida, actually. The handouts that I gave you are specific, some of them are specific to our area.
Do you want to do this? You want me to advance?
I'll let you advance. Thank you. I'll just give you that.
You're on the table.
One of the handouts that you have is prepared by the Southern Poverty Law Center, and it's about something called direct file. And after the presentation, you'll know more about what that is. The other ones are specific to your county, and these are materials that are put out by the, what's it called? The Carruthers Institute, which is a think tank that specializes in juvenile justice, and particularly in civil citations, keeping track, collecting good information about it. And so civil citations and direct files are the two topics that we're going to talk about here. When I talk to lawyers and they talk to me about what they do in court and beyond, what we're trying to do is keep kids out of that system altogether if we possibly can. And that's what we mean by saving futures. A child who gets mixed up in that system frequently will get a record, and after they get through doing whatever they have to do to make things right with the justice system, they have a record which follows them around for the rest of their lives, making it hard to get a job and making it hard to find a place to live. All of these things, just their life becomes much more difficult because of that record that they have. So our aim, of course, if possible, is to keep people from getting tangled up in that system. And so, now I wish I had the clicker. For the next slide.
Oh, I forgot to
What are
say
you
something
doing?
also. If you have questions, we give you a 3x5 card, write the question on the 3x5 card and hand it down the aisle.
I was getting you water.
We hand out,
I've got water.
hand out the card.
Thank you. I'm getting such a good care. The mission of the statewide Juvenile Justice Committee is this. Our mission is to improve outcomes for at-risk youth in Florida by supporting and influencing best practice policies through education and advocacy. And of course, the only way you know what best practices are is by study and by looking into the results of various places that have tried different things and collecting data on it. You can advance, Bill. The best place to get data is from the Juvenile Justice website for the state of Florida. They break it down by county and they break it down by circuit so that you can get really good information about what's going on where you live with the juvenile justice system. Under Florida law, a child less than 18 years old is considered a juvenile, and children that break the law will be held accountable, usually in the juvenile justice system, unless they get plucked out of that by direct file, which we'll talk about in just a minute. But usually they go through the juvenile justice system and they appear before a juvenile judge in what they call a delinquency proceeding. The sanctions in the juvenile court they have lots of different programs. They have residential programs where the kids are kept. They also have community-based programs. They have various things that they tap into that are already in the community in order to help the child do what they need to do to get ready for life beyond. In the adult system, if they are plucked out of the juvenile system and they are put into the adult system, they don't appear before a juvenile judge. They go before a circuit court judge, who is an adult court judge. And that judge can decide to use juvenile sanctions if the child, if he or she thinks that's the right thing to do. But the child still has an adult record that follows them for the rest of their life. Okay, the process within the juvenile system. Click. This came directly from the website for the Juvenile Justice of the state of Florida. If a child comes in contact with law enforcement and that law enforcement person has been properly trained and the child meets certain criteria, then he can get a civil citation, which we'll talk more about later. But notice that doesn't connect to the rest of the system, because that's what happens. He goes through a process with the civil citation, but he does not end up with the record and the ruination for the rest of his life. If, however, on the other hand, he's taken into custody and he gets that's a risk assessment to see how dangerous he is to the community, and they decide either go down to their diversion program, and that would be something instead of jail, a diversion program, possibly extra school, a separate school, and other things that they do, they put in place, and I cannot name them for you, I'm sorry. Or they can go to adult court, and that's with the direct file that we were talking about. Or he can continue in the juvenile court and get, these initials stand for assessment tools that they use at those levels. Okay, back up to the DRAI assessment. If they are at risk, if they are risky to the community, then they're put in secure detention. This means they are incarcerated. They're in prison. And at that point, they can go through the adult court, or after they're all in detention and everything, it can still go to court and the case can be dropped, or different other things can happen to it here. Where we are talking about today primarily is over here on this side of the screen, and it's the civil citation and also the process for getting a kid into the adult system, which is where we do not want them. Okay, next. Okay, what's a civil citation? You can think about it kind of like a traffic ticket, but there's certainly a lot more to it than that. The good thing about it is if the child goes through successfully through a process with the civil citation, then that child does not have the adult record, does not have a felony record. And we'll talk about direct file next. Go ahead. It is an alternative. It's for less serious youth behaviors. And it's an opportunity to avoid arrest and prosecution. And we've got the statute down there if you want to look it up. Next. And these are some of the statutes. A civil citation is there are other diversion programs other than civil citations. We're focusing on civil citation. But the civil citation is a program that's established at the local level. It's the person who is in charge of that is actually the state attorney, but he has other people. In fact, there was a law passed last year that told him to set up a committee that included judges and law enforcement and a lot of other people to set up the criteria and what happens with a civil citation, because it varies from circuit to circuit and actually from county to county. A law enforcement officer is, you know who they are. But under a juvenile civil citation, a law enforcement officer, upon making contact, can actually make the decision that this is not serious, this is a first-time offender, this is a young child, or whatever else is required for him to evaluate. And he can decide on the spot that this child needs a civil citation instead of being handcuffed and dragged away to court. That maximum of 3 used to be the statewide law. It's no longer the statewide law. The state does not say that you can only have 3 civil citations before it's an arrest. However, the local district can decide on if they want to say, okay, after 3 you're in jail, then that's up to the local people. I was going to say something else a minute ago.
Paula, is that what we've said in Escambia County, that there are 3 and you're out?
I don't know. That law went into effect in July, and I haven't, And so he was supposed to set up his committee and make those decisions, and I haven't heard what the decision was. Thank you. Okay, so as I said, each county decides, but actually, each law enforcement agency can make up its own mind about things. A child, depending on where he runs into the law enforcement, may get widely different effects or widely different consequences for what he did, even though he may have done exactly the same thing. One of the things that the league would like to see is consistency throughout the state, so that a child in one county might go to jail and a child in the next county for the same offense might get civil citation or might get it dismissed. You know, it's very, very variable across the state. And one of the things that we would like to see is some consistency, some rulings down from the top that would give people some guidelines so that it's not up to each circuit and each state attorney and each law enforcement agency to make up their own rules about it. Okay? And I want you to know it's not like a traffic ticket. You pay your fine and you're okay, or pay your fine and go to traffic school and you're okay. This is a lot more elaborate than that. They have lots of criteria. You can change that now. I think they list some of them. They can have, in fact, they probably will have community service hours. If there's restitution to be paid, they need to pay the restitution. They frequently have to write a letter of apology. If they damaged school property, then they would have to write a letter of apology to the school and to the superintendent. They will get counseling or treatment if that's indicated. If, for example, drugs are involved, then they are required to do drug treatment. And they do have to pay the fines and administrative costs, which sometimes are quite onerous on the parents because the kid probably doesn't have any money. And they go through a risk assessment to see what is likely to be the outcome of what they're doing. Are they more likely to offend, or is this the first time when he's scared to death and he's going to do everything just right and his parents are going to be supportive, and so we probably won't see this child again. So the risk assessment is done at the juvenile level. We have a juvenile center here where they do these risk assessments. We're lucky. Not every county has one. Okay, go ahead. So the eligibility for a civil citation. These are some of the things that the kid can do. The number one thing is trespassing and burglary. Those are the two ones that are most likely to get a child in trouble. Trespassing, vandalism, those things. Disorderly conduct. Oh, I have to tell you a story. About, I guess about a month or 6 weeks ago in Orlando, Florida, 2 6-year-olds were arrested, put in handcuffs, and led away out of the school because they had tantrums in the school, and one of them kicked the school resource officer, so that was assault and battery. 6-year-olds. There is no lower limit in when a child can be arrested in the state of Florida. There's just no lower age limit. I have been told that there has even been a 5-year-old at some point, but I don't know where or when. But these two were very recent, and they were both in Orlando. And thank goodness the state attorney there decided not to prosecute them for assault and battery. I mean, 6-year-old. So there's a lot of gaps and stuff and mistakes, I would say, within the juvenile justice system the way it's set up now. And one of the things is training for the school resource officers to use their own good judgment about when this is a discipline problem for the school and when this is a actual breaking the law. Too often now, the child is out of hand, the teacher can't teach the rest of the class, and so the school resource officer becomes a resource in that case when they really shouldn't. The schools need more support in the way of social workers, nurses, other people within the schools, but that's a separate talk. But anyway, the school resource officers need more training so that they will know what's appropriate, and it gives them the tools to work with. If you are trained to arrest people, that's what you're going to do. Okay, next. Okay, additional process points. For one thing, it's a lot easier to give out a civil citation than it is to take the child in and fingerprint them and do all of the rest of that. And if they get a civil citation, then they're not set up to miss school, to go back to court over and over again, pay lots of fees and fines, and it's an easier process for every reason. Okay, next. And the overwhelming data is how much money it saves. An arrest, pre-arrest diversion can cost up to $4,000. The cost for a civil citation, look in number 2, is approximately $386. Think of the cost savings. What can we do with that money? I'll tell you what, we can do some training for the school resource officers, but we can also set up diversion programs. We can set up programs for kids in need so that they can have somewhere to turn before they ever get in trouble with the law. Gives them, that's what we can do with that money. Okay, that's all I'm prepared to say about civil citations, although I could say a lot more. If you look in your handout, okay, this is some of the statistics that we have accumulated. This comes, I said, from the think tank, which is called the Carruthers Institute. And it gives you statistics which are pretty much locally, well, it does it county by county. Something was buzzing. Okay, if you look at the where it says law enforcement agencies, on the left here, or right, or whatever side that is, what that's talking about is every time the child has committed one of those sort of minor offenses, and is not doing anything terrible, and the police officer has within his training, supposedly, that he can give a civil citation. This tells you the statistics in your county on how often that happens. In Gulf Breeze Police Department, I'm just going to start there. Gulf Breeze,
Lean against the stuff.
what?
You're leaning against, that's it.
Oh, that's why it's buzzing. Okay. The Gulf Breeze Police Department, when the child is eligible to get a civil citation instead of being arrested, half the time they will get the civil citation. So those police officers have had some training, but they just don't exercise it as often as they might. The Santa Rosa County Sheriff's Office does worse. 25% of the time, that child will get a civil citation instead of being arrested. The rest of this is, well, that's the easy part. In Escambia County, looking at the same place on the second page of your handout, right here. In Escambia County, the Escambia County Sheriff's Office, 30% of the time when the child is eligible for a civil citation, they get one. That means 60% of the time, they don't. Let's see, no, I'm sorry, 70%. The Pensacola Police Department does much better. 76% of the time, the police officer will give the civil citation instead of. But there are statistics like this all over the internet where you can find out what's happening statistically, now, not in individual cases, but statistically in your area. Okay, now we're going to talk a little bit about direct files. It's the other thing that we're working on here. This is transferal of a child from the juvenile system into the adult system, which is wholly in the hands of the state attorney. Currently, there is no real process to do anything else. The state attorney looks at the records, looks at whatever he or she wants to look at, and decides, yeah, this one goes to the adult system, this one goes to the juvenile system. So, sole discretion, total power. That's something that we would like to see changed. However, we'll go through that a little bit more later, exactly what we would like to see happen. The result of this is that Florida prosecutes more children as adults than any other state, including New York, California, Texas, places that have more kids actually. During 2016-17, there were more than 1,100 kids prosecuted as adults, and hundreds more were threatened with adult prosecution. Threatened. That means that when they were sitting there and being interviewed before everything was decided, when they were just brought in and they were sitting there and being interviewed by the attorneys and the police or whoever is interviewing them, they can say, if you just sign this right here and it waives your right to a trial or to whatever, or if you just confess here, well, everything will be fine. But if you don't, then we're going to turn you over to the adult system and they have no mercy. And so it's that kind of threat. If any of you have seen the documentary done by Ava DuVernay about the New York, the Central Park 5, those 5 kids who were accused of raping and killing a woman in New York in Central Park. They were questioned like this, and they were threatened like this. And they eventually all confessed to something or another that they didn't do because they were threatened and bullied. And this is another way in which kids can be threatened or bullied. The Central Park 5, they didn't use exactly those threats, but it was the same kind of questioning process. Okay, and of course there's racial disparity. Children of color are more likely to be prosecuted as adults than are their white peers for the same sort of problem. Children of color are 67% of the children who are arrested in Florida, but they are 77% of those that are sent on to the adult court for whatever reason. Okay, go. There were 2 types of direct file. One of them was mandatory. That meant if you had this age, this problem that you were committing, whatever it was, then you automatically were direct filed into the adult court, kind of regardless of your age. If your age should be taken into account, but we have had kids tried for murder when they were 10. You know, there's no bottom limit to what people are allowed to do. Mandatory was certain offenses and certain other circumstances was automatic. State's attorney didn't even have to read the paper, just it went automatically. Discretionary occurred when, according to the state attorney's judgment and discretion, the public safety requires that kid go through the adult system. 70% of people who go into the adult system, the kids are put on probation. They're out. What makes you wonder how dangerous they were in the first place to be put into the adult system. It's just one of those things. Okay, next. These are the goals. What did we advocate for in the last legislative session? We wanted to eliminate mandatory direct file, and we wanted to put in a process of due process instead. And we'll talk a little more about what that involves. So next. And we had a win. Mandatory went away. It's still at the total discretion of the state's attorney, but it is there's no longer any category that automatically, without anybody thinking about it, goes into the adult system. That was a real win. Now, we had a bill with lots of things in it, And this is the one we got. So we celebrate the wins, and we'll be back with those other things that we want. Loss. Our bill also had in it a due process section, and that did not pass. I think that's explained further, if you'll click. Yeah, this is the due process. It would involve a judge creating a fitness hearing so that the child's case can be made before the direct file recommendation is accepted. And this allows the judge the flexibility to determine where the child should be housed while he's awaiting trial. Should he go to jail, or should he be out on bail, or you know what? It eliminates direct file for 14 and 15-year-olds altogether, and it reduces the number of direct file offenses for 16 and 17-year-olds. And it creates an age limit, finally, an age limit of 14 for indictment, so that it matches other adult transfer methods. Back up just a minute. When we, in Escambia County, we had a lot of big hoorah, we had lots of programs, and we finally went to the I'm talking about the league, with other people, the Southern Poverty Law Center, the ACLU, and other people. There were a number of groups that were involved. We went before the City Council and the County Commission, and we got them to sign a petition to our legislators to install this sort of system for the judge to be involved. And it passed our City Council and our County Commission, and it hooked up a lot of news in the newspaper and on the radio and around. And the state attorney got a little nervous, and he came on the radio and said he wasn't doing anything wrong. And he also showed up. Well, he didn't show up at any of our hearings, obviously, but I went to see him, and I showed him the statistics that Escambia County sent more kids to by direct file into the system than any other county in the state, by almost 100%. I mean, twice as many from Escambia County as from any other county in the state. And his eyes bugged out. And the next day in the paper, he said, we've made some revisions in our process, and from now on, a 16-year-old who commits a felony is not automatically sent to the adult court. And that cut down on a bunch of them, because apparently they were just direct filing a lot of kids based on the fact that they were 16 or 17. Okay, that's just a neat story. I felt like that was a personal win. And in fact, the state league gave me a little plaque when I went down there, because our rates fell by 61% direct file. It's right there in all the statistics.
Where do we rate now then?
Beg pardon?
Where do we rate? Are we still first?
Oh no, we're not still first.
Okay.
We're down more in the middle of the pack. It's still not good, but it is. We are not so outstandingly awful as we were. Next time. Okay, so what are we doing? One of the things is we take action. There are a lot of ways to take action. I personally went and we had our legislators, what's it called? When our legislators come to town and they sit at a table on a stage and listen to the public talk about what they want. And so one of the ways I took action was I went down and I talked about these problems, civil citation, direct file. And I did it last year too. But anyway, that is one way you can take action. It makes more of an impact if you have more than one person doing it. And so letters to the editors are nice. That's another way to take action. If you ever have an opportunity to be interviewed about it, and you don't want to be interviewed, send them to me. I'll talk to them. Okay. Locally, we do have a Juvenile Justice Committee. I'm chairing it along with Shirley Lewis Brown. We are the co-chairs of the Juvenile Justice Committee. But form coalitions. We are in coalition with the Southern Poverty Law Center, statewide as well as locally. And the ACLU, I'm in contact with them. Those are the major coalitions, but I'm also, and those are statewide coalitions, but I'm also locally in coalition with the NAACP and the let's see, Movement for Change, two black committees that I talk to regularly. And they have a conference call once a month. We had it this last week, where we hear from other places what they're doing and what's happening with the law. They get people to come in they get legal people to come in and talk about it too. And if you are interested in any of this and would like to maybe write a letter to the editor, then let me know, or you don't even have to let me know. Just send me your letter and I will read it and pass it along. Okay, next. Charlotte Nickelmo is our state justice chair. And I can put you in touch with her. She runs the conference call that is once a month. And she put together this slideshow for us. Next.